In view of recent statement of Ranganath Garu that he will not spare illegal constructions made after 1924, what will be the fate of the owners of demolished houses?
My pleasant namaskarams, good morning, and welcome to all the viewers of Law Times and employees and owners of this esteemed YouTube channel. We are well aware that in view of completion of 6 months of making of Hydra and demolition of several houses which are claimed as constructed by way of different types of constructions in the FTL zone area, buffer zone area and other places. For the last 6 months, there is a statement made by Sri Ranganath Garu, Commissioner of Hydra, that he will not spare, rather the Hydra will not spare the illegal constructions and unauthorized constructions made after 19-07-2024, and he will not take steps for demolition for the houses that are made or constructed prior to that date. He says that already a route map is made and 12 rivers and 8 parks are protected by him and Hydra, and satellite image aerial drones used and reverse satellite image is made in 1095 rivers. He also says that nearly 200 acres of land of government is protected, and real estate industry is now going in right directions in view of demolition of 314 unauthorized constructions in 27 areas for the last 6 months. Now the people are understanding that they are not entitled to construct any constructions in FTL and buffer zone areas, and also if any constructions are made before purchase, the people will take care of these aspects. He is requesting the people to understand the working of Hydra. Nearly, he says that 5,800 complaints are received by him, and most of the complaints are in respect of the sites in which constructions are made illegally and unauthorizedly in 27 municipality areas. He says that GHMC Act is amended and powers are conferred on him, and basing on the same he will make use of the law and get punishment to the guilty. He says that already DPRs are made for 12 rivers and permissions also are being taken, and they are making a system and executing the work by forming 30 DPRs with the help of Dr. Weather Radar, and he is also saying that 72 DRF authorized organizations are coming and which are located at the head office of DRF at Nagol, and they will take care of the environmental conditions and assess the time to time, and for the benefit of Hydra, Doppler weather radar is also coming, and it will see that through FM channel messages are being intimated to all. He also said that apart from that FM channel, he is also for the benefit and interest of public will use the FM channel and get the uh, constructions regularized if made in correct way in correct areas, and if any unauthorized constructions and illegal constructions are made violating the rules, he will not spare and he will demolish it. But the question is, what about the constructions that are made prior to 27 19 07 2024? For them, he said that he will not act against them and try to take steps for demolition. He only says that whatever constructions that are made after forming of Hydra and subsequent to 19 07 2024, he will see that they are demolished. In this regard, people are asking about what happened and what will be the compensation that may have to be paid to the owners whose buildings are demolished recently under the guise that the alleged constructions are in violation of the municipality laws and rules and regulations. Now the question is, what is the law? Former residents of Maradu apartments in Calcutta, they are feeling they are the victims of delayed justice. On record, when you see the Honorable Supreme Court, while ordering for demolition or pulling down of several constructions of 4 apartments, Golden, Kailaram, Alpha Serene, H2O Holy Faith and Jain Coral, ordered that 25 lakh rupees for each apartment has to be paid by recovering from the builders as well as the erring government officials who are responsible and gave clearance for constructions in violation of the coastal regulation zone. But subsequently till today, the owners of the demolished houses have not got the compensation. So they claim that there is undue delay because of which injustice is done to them. The rationale behind ordering for demolition was that the constructions are made in violation of the CRZ 2011 rules which were there in force at that time. Even though Maradu Panchayat permitted the constructions, but without obtaining the prior permission of the Kerala Coastal Zone Management Authority, which is a prerequisite under that rules, the constructions are ordered to be demolished. Accordingly, they were demolished. But the point is, subsequently 2011 rules, CRZ rules were replaced with the CRZ 2019 rules. So, under the CRZ 2019 rules, by getting its coastal zone management plan approved by Union Ministry of Environment, Forest and Climate Change, some benefits are given. Now these people whose constructions are demolished under the guise of violation of the CRZ 2011 rules, they are claiming, please pay some compensation to us in the light of the judgment of the Honorable Supreme Court that each apartment has to be paid when demolition is made an amount of rupees 25 lakhs. But now top court has changed its view. Now the court says that the buildings could have been saved by imposing heavy costs on the violators. Instead of demolition, if heavy costs are ordered to be paid by the violators, that amounts to justice according to the Supreme Court latest view. Earlier, it ordered demolition of Capico resorts built in Rutu, an island in Vemaband Lake in Alappuzha district. Likewise, it also ordered for demolition of the constructions for violations in respect of a resort in Kerala. Even Capico resorts case also, the court ordered for demolition. So, the Honorable Court changed its view. It wants, if compensation is ordered to be paid, that will meet the ends of justice. Likewise, instead of demolition, 1 crore is ordered to be paid by the DLF Universe Limited in respect of the constructions that are made in violation of CRJ rules at Chilvanur, which is a place situated at a distance of few kilometers away from the Maradu apartments. Not only this, the Honorable Court appointed Gaurav Agarwal, amicus curiae, to consider about the constructions made with the permission of Maradu Panchayat to find out whether the construction of new apartments would be possible at the site where the 4 structures once stood. That means now CRJ 2019 rules are allowing to make constructions and also not for demolitions of the constructions already made. Now, in view of this fact, since the new region permits construction along the building line of the existing building built-up area, it also allows construction activities towards the land side of the unauthorized structures. We have to wait and see whether the people opt for making an entry into the areas where constructions are already made and protect them. They are claiming if some amount is ordered to be imposed as a compensation and paid, that may amount to justice to them, or otherwise allow them to have the benefit of CRJ 2019 regime rules benefits and also the subsequent requests of the developers, builders and house owners for granting permission for construction. That prompted the top court to explore the possibility, and for that reason it ordered to have a report from amicus curiae Gaurav Agarwal. So, now the holding where the Maradu apartments once stood was included in the Zone 3 under the CRZ 2011, where the no development zone was 100 meters from the high tide line. Now the change of rules are there in view of the 2019 coastal regulation June, and further where the restrictions on constructions have been significantly eased, they have removed. The new regime permits construction along the building line of the existing built-up area. It allowed construction activities towards the landslide of the authorized structures. Landslide of the authorized construction structures means that the constructions that are made towards the land side, not towards the river side, can be allowed to be protected. And further, instead of demolition, if some amount is ordered to be paid as costs, with that amount the authority could use it for better enforcement of CRZ rules. This is the contemplation or concept of the top court now. But the authorities are busy in building line to demarcate the areas and assess the extent to which constructions are possible. The developments have left the erstwhile residents funning justice delayed, they say is justice denied. Now important thing is who are the victims in these cases. Sometimes it may be one of the developer or some company owner. For example, demolition of a apartment has sent to a strong message that the environmental violators would not be left scot free. It also says that the Maradu apartment owners who lost their abode feel that they are the victims of the delayed justice and wisdom that prevailed on the top court. They paid dearly for no fault of theirs. As the top court contemplates undoing with many perceived as injustice committed to the innocent buyers, his earlier order is unlikely to bring them any solace. Now, even though order is there to pay 25 lakhs, but that is not paid. The order is made in the year 2020 in respect of 350 apartment owners, but that amount is not paid. So 24 years have elapsed. So now the Supreme Court is thinking, instead of ordering, rather continuing the orders for payment of compensation, if these fellows are allowed as per 2019 zone rules to make constructions in the area where their houses were demolished or nearby towards riverside area, then justice will be there to them. So now the question is, if the Supreme Court or government doesn't take steps for making either payment of compensation or allowing the encroachers whose houses were demolished to make constructions, that amounts to injustice. So better do justice as to be seen, not only to be heard. So for that reason, either you pay 25 lakhs compensation to the builder and employees. Otherwise, what will happen? Justice delayed is justice denied. So I, you and all are expecting that the law has to be implemented strictly. At the same time, wherever there is a need to think in a humanitarian way for protecting human rights, the illegal demolitions, if any, of any building have to be protected. Law has to be implemented. I feel that it will be done. Thank you.